Right now, tonight, your family cannot touch a single dollar in your bank account if you died in the next few hours. Not your spouse, not your children, not the person you have spent your entire life building a future for. A will would not help them. A notarized estate plan would not help them. An attorney who charged you $800 to draft documents that say exactly who gets everything would not help them. There is one free form, one single form that bypasses all of it. Your bank has it. It costs nothing to file. It takes 10 minutes. And the reason most people have never been told it exists comes down to something simple. Nobody whose paycheck depends on the current system has any financial reason to tell you about it. Stay with me through this entire video because the section near the end, the one about 3 specific mistakes that trap even careful people who thought they had this handled, is the part that will change how you think about every account you own. Let me tell you about Dorothy first, because her story is the reason I made this video. Dorothy was 71 years old. She was a retired school teacher from Illinois who had just sold the family home and walked into her local bank with $350,000 from the sale proceeds. She opened a standard savings account. She was thorough. She hired an estate attorney for $800, had a comprehensive will drafted, witnessed, notarized, and clearly naming her 2 adult children, Michael and Sarah, as equal beneficiaries. She put the will in a lockbox under her bed and called Michael to tell him everything was handled. It was not. Dorothy suffered a stroke and died. Michael and Sarah flew in. They received a $11,500 funeral invoice, and Michael took the death certificate and the notarized will to the bank. The branch manager looked at the account screen, looked at the will, and slid the documents back across the counter. Dorothy had never filed a payable on death beneficiary designation. The account held only her name. The balance exceeded the state's small estate threshold. The bank had no legal authority to release a single dollar. A will is a letter of instruction addressed to a probate judge. POD accounts are governed by a contract between the account holder and the bank, not by the deceased's will. A will carries no weight at a bank counter. The bank's obligation runs to the contract on file, and the contract named no beneficiary. The account was frozen. Michael and Sarah walked out of the bank with nothing. They put the $11,500 funeral bill on their credit cards at interest rates above 20%, while $350,000 of their mother's money sat 20 feet away behind a counter they could not legally cross. Then the probate process began. Court filing fees, a mandatory publication notice in a local newspaper required by Illinois law to notify unknown creditors running for 3 consecutive weeks, an executor bond premium, a probate attorney charging a percentage of the gross estate, standard practice in many states. The mandatory creditor waiting period, which in most states runs 3 to 6 months by law, held the case open for months before a single distribution could happen. From start to finish, the family waited 14 months. They lost over $12,000 in documented fees. The interest on the credit card kept running the entire time. Dorothy did nothing wrong. She had the will, the notary, the attorney. None of it reached inside a bank contract. Here is the legal architecture that produced this outcome, because understanding it is what makes the fix make sense. The framework that controls your bank account after you die was established by the Uniform Probate Code, finalized in 1969 by the National Conference of Commissioners on Uniform State Laws. Every state in the country now operates under some version of it. That framework established something most Americans have never been told. The will controls only what passes through the probate estate. Assets with their own beneficiary designations move on a separate track. Your will governs your furniture, your car, your personal property, the physical contents of your home. The contract between you and your bank governs your cash. They operate on completely separate legal tracks, and the bank contract wins every time they conflict. A POD designation in a will conflict will typically beat the will. If the account says POD to Alex, but the will says all my bank accounts to Jamie, Alex gets the POD account. Jamie can challenge it in court, but courts almost always uphold the beneficiary designation. This is not a loophole. This is the system working exactly as it was designed to work. When you die without a named beneficiary on a bank account, the account does not transfer to your heirs. It transfers to your estate. The moment it transfers to your estate, probate opens automatically. In most states, the threshold that triggers probate is somewhere between $50,000 and $100,000. For most retirees, Any meaningful bank balance clears that threshold. The court then moves on the court schedule. There is a mandatory creditor waiting period built into the law in most states, typically 3 to 6 months, during which anyone who might have a claim against the estate must be given the opportunity to come forward. No distribution happens until that window closes. The funeral does not wait, rent does not wait, grief does not come with a financial timeout. There is one form that operates on the same contractual track as the bank and wins. It is called a Payable on Death Designation, or POD. All you need to do is properly notify your bank of whom you want to inherit the money in the account or certificate of deposit. The bank and the beneficiary you name will do the rest, bypassing probate court entirely. Here's exactly how it works. The form asks for each beneficiary's full legal name, date of birth, and contact information, and becomes active immediately once submitted. As long as you are alive, the person you name to inherit the money has no rights to it. You can spend the money, name a different beneficiary, or close the account. You maintain full control. A payable on death account transfers funds directly to a named beneficiary after death, bypassing probate. Beneficiaries claim funds by presenting a certified death certificate and valid ID to the bank. No judge, no attorney, no filing fees, no mandatory waiting period, no 14 months. The cost of filing a POD designation is zero. This kind of account has been called the poor man's trust. A free payable on death account designation avoids probate just as well as an expensive lawyer-drawn living trust would. Now I need to walk you through the 3 failure points, because there are 3 specific ways people end up in Dorothy's situation, even after they think they have handled this. The first failure point is no designation on file at all. This is the most common situation. You open the account years or decades ago. Nobody at the bank asked you to name a beneficiary. You signed the signature card and left. You assumed your will would handle it. Don't try to change a POD beneficiary by naming a different beneficiary in your will. About half the states don't allow a POD designation to be overridden by a will. Most estate attorneys draft wills. They do not file bank beneficiary forms. Those are 2 completely separate documents at 2 completely separate institutions, and almost no one explains that when you write the check for the estate plan. The second failure point is an outdated designation. This one is more dangerous than no designation at all because it gives you a false sense of security. You named someone 20 years ago, an ex-spouse, a parent who has since died, a sibling you no longer have a relationship with. That name is still on the form. That is who the bank sends the money to. The will says something entirely different. It does not matter. The designation on file at the bank controls, period. POD designations should be reviewed after major life events, such as marriage, divorce, the birth of a child, or the death of a previously named beneficiary. The third failure point is the joint ownership assumption. Many married couples believe that because they are married, all accounts automatically transfer to the surviving spouse. In a number of states, that is not true. Joint tenancy with right of survivorship is a specific legal arrangement that must be explicitly created and documented at the bank. Marriage alone does not establish it. And there's a trap hidden inside the most common attempt to fix this. Many seniors add an adult child directly to their account as a joint owner, thinking it gives the child easy access to pay bills if something goes wrong. The legal consequence is severe. Once you add another person to your account as a joint owner, the law in most states treats that money as partly theirs right now while you are still alive. If your child is in a car accident and faces a lawsuit, the plaintiff can pursue your bank account. If your child goes through a divorce, their spouse can claim a portion of your savings in the settlement. A POD designation grants your beneficiary 0 ownership rights while you are alive. Your money stays entirely yours until the moment you pass. Then, the transfer happens cleanly on contract with no court involved. One protection. 3 ways people accidentally bypass it. Here's what you need to do, in order, before you close this video. Step 1. Go to your bank this week, in person or through your online banking portal, and request the Payable on Death Beneficiary Designation form. Every FDIC-insured bank is required to offer it. If the teller does not know what it is, ask for the branch manager. Step 2. Name a primary beneficiary using their full legal name, date of birth, and social security number. Do not write nicknames. The social security number is how the bank verifies identity at the time of transfer. Without it, the payout can be delayed. Step 3. Name a contingent beneficiary as a backup. If there are no living beneficiaries at the time of your death, the money in the account becomes part of your estate and goes through the probate process. A contingent beneficiary catches the account if your primary dies before you do. Step 4. Submit the form and request written confirmation that the designation has been recorded. Keep that confirmation with your important documents. Step 5. Check every account separately. POD accounts are typically bank accounts such as checking accounts, savings accounts, or certificates of deposit. TOD accounts are typically associated with investment holdings like stocks, bonds, and brokerage accounts. One form filed on your checking account does not cover your savings account, and it does not cover any certificates of deposit. Each account is its own contract. Each contract requires its own designation. Step 6. If you hold stocks, bonds, or mutual funds in a brokerage account, contact your brokerage and file a transfer on death designation, which operates on the same legal principle as a POD, but covers investment accounts. Step 7. Review your retirement account beneficiary designations right now. IRAs, 401ks, and 403bs already operate on a transfer on death principle under federal law. But if you filled out that beneficiary designation when you first opened the account decades ago and have never revisited it, an outdated name on a retirement account can be just as damaging. Under federal law, a named beneficiary designation on a retirement account controls over any conflicting will or divorce decree. Step 8. Visit every 3 years or after any major life event, a death, a marriage, a divorce, a new grandchild. These are all moments when the name on file may no longer reflect your actual wishes. One more thing worth knowing. A POD designation is not a complete estate plan. While the account itself may bypass probate, other assets may still require the court's involvement. Real estate, personal property, and many investment accounts have their own rules. The POD handles your bank accounts. It does not handle your home, your car, or the physical contents of your house. For a complete plan, a POD designation works alongside a will, not instead of one. What it does completely. It takes your bank account off the probate track and puts it on the contractual track where it transfers directly to the person you named, with nothing more required than a certified death certificate and a valid ID. POD accounts work well for straightforward finances. They are free, transfer funds quickly, and avoid probate. Tonight, your family cannot touch a single dollar in your bank account if you die. That is true tonight, unless you file this form. Go to your bank this week. Ask for the POD form. It costs nothing, it takes 10 minutes, and it is the single most effective thing most people can do right now to make sure their family is never in the position Dorothy's family was in. Share this with one person you love who has not done this yet. There is a real chance nobody has ever explained to them that their will has no authority at a bank counter. Subscribe and turn on notifications because every week I cover the financial and legal realities that protect your money and your family, and I make sure you actually understand them. Drop a comment and tell me one thing. Did you know before watching this video that a will carries no legal weight at a bank counter? I read every comment, and the answer tells me exactly what most people are missing. I will see you in the next one.